And we're live, so
All right.
welcome everybody. And Sebastian, off to you.
Hi, everyone. Happy Friday to you. Already the end of the week. Today, we are going to host a special kind of event, which for the very first time, we are going to have a masterclass at the Blockchain Game Alliance on the topic of the Eula and T&C term of condition for blockchain games. So we'll get to deep dive into the topic. Before that, I'm going to give a brief introduction about the Blockchain Game Alliance for those of you who are not yet familiar with what we are doing. We're essentially a non-profit organization that's been now growing to more than 235 members with a main mission to promote the adoption of blockchain technology within the game industry. We are trying to spread awareness about the benefit of DeFi, NFTs, decentralized gaming, DAOs, blockchain in general, on how they can highlight potential for game developers, game studio to create new games, publish games, interact with players, and build a stronger community around games. We provide an open forum for individuals and companies to share knowledge, like today, to collaborate, to learn, to participate in working group, to network with each other, generating potentially business and other kind of collaboration in the space. We are here to provide additional visibility by representing all blockchain game companies, running events where they can showcase their product and services. And of course, we are here to advocate for adoption of blockchain within the game industry. I'd like to give a big thanks to all our sponsors, namely AMD, Ancora Interactive, Ubisoft, Vulcan Forge, Illuvium, Mobox, One Way Block, Zaya, Star Atlas, Arc.io, Non-Fungible, Digital Entertainment Assets Group, GamerHatch, Tap.io, IOI, TriumphX, Algorand, AnarchX, Boston Protocol, Chromia, Matic, Animoca Brand, Contribute, Consensus, Galaxy, and Tezos. We're really grateful to all of them for their additional support to the mission of the BGA. And that mission, that's shining through all our members, more than 235 companies coming from all different corners of the industry, whether they are blockchain games, chain and protocol games, press and media, investors, development solution, esport, or others. We run more than one event a week now at the BGA. Sometimes there are interviews with industry leaders, there are workshops on various thematics, there are panels, series of panels on key topics to help understand certain matter that are happening now in the industry. The monthly new member presentation event, as well as now the monthly demo day where companies get a chance to showcase their products as they are now live. We also offer free speaking opportunities at various conferences. And we try to build a culture here around diversity and inclusivity within our industry. Without any further ado, I'd love to introduce our speaker today, Gianluigi Guida from Guida and Associate, who will be running this workshop on the topic of Eula and T&Cs for blockchain games. I'll let him introduce himself within 10 seconds. Just like to invite you to follow the Blockchain Game Alliance on our Twitter, Medium, Telegram, and Discord if you want to be notified about our upcoming event, if you want to receive the newsletter about what our members in the industry are doing, and or just stay updated with what's happening in the space. That's it. Let's have a great event, a great workshop. Thank you, everyone, and welcome Luigi to the stage.
Thank you very much, Sebastian. It's really a pleasure to be here with you, and thank you very much for having me here. Let me share my screen so we can start with the presentation. I'll try to keep it short. Here we go. There we go. You should see it now, right? Okay. So, yeah, thank you very much. So we're going to talk about some legal stuff today. Hope you will find it interesting. Actually, it's some part of that the company should take in consideration when running its business. And since we are going to talk about IP laws also, I just want to say that the pictures here, I I asked for permissions to show this picture. This is actually from a client of mine. He gave me his permission. So all the things that we will see We will talk better about IP rights, for example. Okay, let's start. So that's me. That's my timeline, a recent timeline. I mean, not so much recent because I graduated in law from the Bologna University in 2005. Then I got my first degree, master degree in law, in information technology law from the Stockholm University. 2007, I worked at Hogan Lovells. It's an international law firm where I had the pleasure to assist clients like PayPal, eBay, Google. It was very interesting. Then I moved to my family law firms. Actually, it was established in 1976. Yeah, kind of some years ago. And I am in charge of the team of new technologies. So we assist companies that are engaged in with the new technologies, such as a video games company, of course, and artificial intelligence, blockchain, and such. Then I moved in 2015 to Seattle, where I got my second master degree in global business law from the University of Washington. And then when I came back in 2018, I was appointed counselor to the Italian Minister for the European Affairs, in which role I had the privilege to draft the Italian fintech law on the sandbox regulation, actually. I don't know if you guys have ever heard about that. It's a kind of pretty interesting law in the fintech field. That's me. And let's start with some legal stuff. So when we use blockchain in the video game industry, basically we can divide two fields, even though they are very connected, very much connected. The first field is the field of the crypto tokens and cryptocurrencies. So basically, when I say we, I mean the company. When we, as a company, we use and we provide to the users the possibility to use cryptocurrencies and crypto tokens, we have to pay attention to some regulations and laws. Unfortunately, and I have to say unfortunately, blockchain, the use of blockchain in the gaming industry is, in my opinion, is really disruptive. In which way? When I was a child, I started to play video games when I was 5 years old. And I mean, still, sometimes, of course, I test the products of my clients, and it's something super fun. But I don't have so much time now, unfortunately, to play so much. But when I started, I remember that everything was, a closed environment. You used to play that video game. You used to score high, to get higher scores and to gain something, to win a sword or something like that. And then you turn off the computer and that's all. Well, now, thanks to the blockchain, things are getting much more interesting than before. Also through the use of internet, of course, because we can actually take something out from the video game. For example, the asset that we created into a video game, and we can move it and use it on another video game. Or we can also collect rewards in Bitcoin, for example, in a video game, and then convert them into money, real money. Or we also can sell the NFTs that we have created for real money. So, this is really something super, super interesting and with huge potentialities. But at the same time, as often happens, technology comes with some sort of restrictions by the laws, in the sense that we cannot do everything we want, basically. Okay, we need to pay attention to the laws that govern our actions and that protect, by the way, our rights. That's very important. So, for example, when we deal with cryptocurrencies, when we deal with cryptocurrencies in the company, some specific laws may apply. And we need to be very careful about these laws. For example, banking laws can apply when the services provided by the company involve some kind of payment through cryptocurrencies, some kind of exchange between cryptocurrencies and fiat money. Pay very much attention to that. I always advise not to exchange virtual currency, the in-game currency, cryptocurrency with fiat, because that's something that could be subject to exchange regulations, which are part of the banking. The main field is the banking. So we need to pay attention to that. Another possible field of law that could apply to the use of cryptocurrencies in a video game, or in a platform that publishes video games. It's basically the same. They could apply. Are the security laws that are basically laws that apply when there's some kind of investment, when the user thinks that he's investing in something that he can make profit from something, from the efforts of somebody else. So, for example, if I buy a crypto token that represents a share in a company, very much likely that securities laws apply. And this is basically the same all around the world. We will talk about that on the applicable law a little later. So we need to pay attention to that. For example, when the ICO, when we had the ICOs in 2017, there was a lot of noise around the ICOs and the qualification of the tokens as investment tokens. The SEC, for example, the American Exchange and Security Commission, closed and charged the founders of several projects and companies because they were in violation of these laws. So pay attention to this too. AML, KYC, anti-money laundering, and know your client laws. This could apply to if, for example, the company is storing the crypto private keys of the users in order to provide custodian wallets. So basically what the crypto exchanges do. But also a company, and I saw some companies, some video game companies that actually provide this service to their users, probably in good faith, of course. They are not aware that this kind of laws could apply. And if you, for example, under the European Union, if you offer this service as a custodian wallet to the users, you are probably subject to the AML rules, which means that you have to be in compliance with several things. Okay, it's not something fun. What does it mean, for example, that you might be subject to banking laws, that you need a license to operate that service. If you don't have that license, you cannot operate. And if you do, you might be subject to criminal laws, criminal charges. So it's no joke at all. And of course, we talk also about tax regime. Who has to pay taxes? The user, the company. It's very important to make it clear, this regime. But another field very interesting is the NFTs field, the non-fungible tokens, which I'm very interested into it. And basically, when we talk about NFTs, we have, from the legal point of view, we could face the same issues as the one that I just said about cryptocurrencies and crypto tokens. but probably with minor intensity. Why? Because it's not so easy, in my opinion at least, that one NFT could be seen as an investment in the share of a company, for example. It's much more probable that the NFT is the representation of an asset, of a tangible asset it could be, or in the case of video game, of intangible assets. So I think it's less probable that they could fall under these regulations, but still we have to pay very much attention because, at the moment, there's not such a clear statement about NFTs. Actually, not even about cryptocurrencies. Some states, some countries have issued laws that clarify, or at least try to clarify, the cryptocurrencies and their functionalities and the laws that apply to cryptocurrencies. But when we talk about NFTs, at the moment, the area is really gray. So we have to pay attention to banking, security, AML and tax regime laws, as well as IP rights, which are the rights that apply to intellectual property creation. Yes, intellectual creations, so intellectual property right, everything that is related to the human creativity, sometimes also to artificial intelligence, but this is another topic. Creativity are subject to IP rights. Why is this? So when we deal with NFTs, we have to know and to make sure that our counterparty, a user or a company, another company, if it is B2B, knows exactly what kind of rights we are transferring. This is something that I see around. It is very underestimated, but it's actually very important. Why I'm telling this? Because if I write a song, for example, okay, I'm the creator of the song, of that song. I own IP rights on that song. If I want to sell my song, basically, I have two ways. The first is to license the use of my song to some users. So basically, I'm giving to a third party the possibility to listen to my song. And that's all. It's a limited license to do something with my song, something with my creation. This could be also a digital piece of art, of digital art. This could be a sword or a skin that I designed in a video game. So I can license this kind of rights, but I'm still the owner. I can do whatever I want on that asset, as far as I haven't granted exclusivity rights to the licensee. In this case, that is the counterparty that takes the license from me. But there's also another way, and this way is to to assign the rights that I have as creator on my creation, on the song. In this case, the difference is that if I assign the rights that I have, the IP rights that I have, I'm basically saying, I'm no longer the owner. You are the owner now, so you can do whatever you want with that. But when we talk about NFTs and the possibility to, identify each NFT, and the possibility to, at the same time, for the owner to create 100 copies, for example, what exactly the owner is transferring to the counterparty? Is it transferring the rights, the ownership of what he, for example, what he drafted, or is transferring just a license, a copy. That's very important, actually. This has a lot of implications from the legal point of view. So it's very important that, when we take in consideration the use of blockchain in video games, and we give the possibility to users to create their own NFTs, well, we really have to pay attention to this, and we have to make sure that the terms and conditions state clearly what's going on. Then, let me just briefly explain the difference between what is an Eula and what is what are the terms and conditions, what the terms and conditions are. So, end user license agreement is an agreement, basically. Both of them are agreements. It's an agreement under which the company grants to the user with the license to play, grants the users the license, sorry, that's a typo, the license to play the video game. So the case is this: the company has developed this video game, wants to sell, the copies of the video game. So basically, the company says, you, user, have the right to play the video game under the rule that I'm setting in this license. It's a license. It's a license. It's not an assignment. The company is the owner of the video game. The user is just a user. Okay? Terms and conditions. It's an agreement, of course. Why it's an agreement? Because both of them are made between the company and the users. It's an agreement under which the company sets the rights and obligations connected to the provision of its services. In this case, it's a bit more complex. So this is the case, for example, of a company that is not only offering its video game to be played. No, this is the case in which the company is offering something else. It's offering some services to the users. For example, if the company has developed its own platform, it's not a video game, it's a platform, and the company is selling some virtual parts of that platform, for example, or some digital assets that derives from the platform, or the company is giving the possibility to the users, and I like this very much, it's giving the possibility to users to create their own NFTs through the platform. This is a service, basically, that the company is offering. In this case, the rules that apply to this provision of services have to be set in the terms and condition agreement. So as you can see, it's more complex than a license agreement. Actually, license agreements can be put inside the terms and conditions agreement. So the terms and conditions can have a field, section, articles dedicated to the license, and generally it's like this. But it's a more complex agreement than the Eula. Okay, just keep in mind that if the company is providing something else than just a video game, it needs the terms and conditions. But the question is, why? Okay, clear. Hopefully it's clear. But which one do I need? It really depends. The best answer preferred by the lawyers is it depends. But in this case, it really depends. It depends on what the company is providing. As I said, if the company is providing a video game, Eula, it's fine. If the company is providing the video game and some other services, it needs the terms and conditions. Also because it has to, the company needs to set the fees. Okay, because if it is providing the services, some fees needs to be applied. It is not just, you buy the video game, the license, of course, to play the video game, and that's all. If the company is providing some services, probably the company wants to put some fees on that, and these fees are repeated in time. For example, to each time that that one user sell the NFTs, the NFT that the user created thanks to the platform, probably the company wants to make some money from that. This is just an hypothesis. In this case, the fees need to be written in the agreement because it's a contract. So, why do you need Eula or terms and conditions? Well, in addition to what we said, you need to, first of all, set the rules of the game. And this means that you want to allocate rights and obligations among the company and the users. The counterparty are the users in this case. So you want to set clearly which rules applies to the users and which rules applies to the companies. Especially you want to make sure which are the obligations of the user towards the company. So what the user can and cannot do with your product or with your services, how the user can use your services, how the user cannot use or should not use your services. But very important is also that you want to minimize risks and liabilities. Super, super important. This is so much underestimated. But guys, if you one day will be sued in court, this is what matters. Risks and liabilities. Is the company liable for something that the user did? No? Well, tell me, the judge will say, well, tell me, where did you make this clear? Have you made this clear? If you haven't, well, probably let's talk about that, and maybe, you could be found liable for something that you didn't want at the beginning. So think about the risks that are involved in your service, in the services and the product that you are providing, and try to minimize at the maximum extent possible the liabilities. How you do this? How can you do that? Well, by writing clear terms and conditions. If you state clearly in the terms and conditions that, for example, the NFT that the user created, thanks to the platform you provided, is in violation of third parties' rights. And I mean, it can happen easily. Actually, it can happen easily. In that case, the company doesn't want to get involved in that and doesn't want to found liable for that. Another example: if, for example, something goes wrong in the marketplace, a company has offered the possibility to exchange NFTs among users. So basically to sell and to purchase NFTs between users. Something goes wrong. We cannot at the moment imagine everything, but something could go wrong. Who is liable for that? The seller, for example, or the company that is providing the service? This is not such an easy, from the legal point of view, answer. For example, I remember when I was working for eBay marketplace, basically. Okay, you cannot imagine how many claims users start against eBay for that, because they say, you're responsible for that, even though basically doesn't do anything, with reference to the product sold by the users. Pay attention to that a lot. Another point, another reason, much more practical, is you want to look and be professional, of course. I mean, if you don't have the terms and conditions and the Eula, and if you haven't set the rule of the game in terms of rights, obligations, and liabilities, well, I don't know how much you could look professional and be professional for the reasons that we just said. Then, sometimes, if you want to publish your game on platforms that allows you to, on some platforms that allow you to publish and distribute your game, such as Steam, for example, just to say one. but there are also new platforms, and we are assisting one in this particular, actually two in this particular field. They're giving the possibility to publish games on through their platform, to distribute games through their platforms. Well, they require you to have an Eula, because they want to make sure that you have some rule in place. Then something that really, I don't know how many times I had to answer this question. So many times. I mean, it's totally legitimate. Total legit. How do you say legit? Yeah, it's totally legit. Can I copy and paste terms and conditions from a competitor or from somebody else? Well, first of all, if you're copying them from, if you think that you're copying them, no, sorry, if you are thinking to copy them, probably you're taking them from a competitor, because probably it is from a party that is offering some kind of services similar to yours. So probably it's a competitor. And actually, you want to give your competitor the possibility to sue you in court. Well, if you want to, you can do that. Because basically, you can copy them, but you are opening a lot of risks. That there are the risks that you will be brought in court are pretty high. Why? Because you're in violation of IP rights of the company, of the competitor. Because the EULA that the competitor has online, if the competitor did everything properly, probably the competitor paid for that work to be done. So once you are copying that work, you're infringing his rights, copyrights in particular, because it's something that is published on its website. So watch out for that. Watch out. You can take inspiration for sure. Take inspiration as much as you want, but please do not copy. Please do not copy them. So yeah, because we have violation of IP rights, among others, actually. And another reason is that each video gaming service, especially those based on DLTs, distributed ledger technologies, as blockchain, requires specific tailored terms, disclaimers, and limitation of liabilities. Why is that? Why? Because we have these possibilities. Blockchain has opened to so many potentialities and possibilities that each service provided is actually different from the other. One thing is just to give the license to play a video game, and you have to be careful also on that. Another thing is to mix the license to play a video game with the ability to create NFT, the ability to exchange NFT, the ability to be rewarded in Bitcoin. Each company has its own services, and this is fascinating from my perspective. It's so fascinating, unbelievable. But at the same time, we need to be sure that those services are offered in accordance to applicable laws, and we need to provide disclaimers. Very important, and limitation of liabilities, of course. Then, okay, we have here some. Just one thing, Serena, Sebastian, I don't have the screen in front of me, so please feel free to interrupt me whenever you prefer, or if there are questions. Otherwise, I keep going.
Okay? Of course, yes, Luigi. I was just going to say I didn't want to interrupt you at the beginning, but I just wanted to tell everyone who's watching this, if you do have questions, comments on what is being shared, I know the topic is quite intense, but I think it's a good time to be discussing it. So if you do have questions, don't be shy.
Thanks, Serena. I like the word intense. Thank you very much for that. Yes, it is. I mean, I understand probably these are not so much fun not arguments, but let's say topics, but at the same time they're super important. So please
they're
be patient.
incredibly useful. So thank you so much, Luigi, for being with us
You're
today and
welcome.
sharing such great content, which, I also remind everyone is going to be available on YouTube, so you can rewatch it later on. But it's an incredibly valuable workshop and research. So thanks again.
Thanks. So the BGA carried out this pool, very important, very interesting pool, just to understand, to have an idea of what kind of services the BGA members are providing. By the way, I mean, if you are not members, I would really warmly welcome you to become members of the BGA, because it's such a great, really, association led by tough people that know their business. Really, please do that, because if you want to be updated, it's really, really, really useful. Very useful resource. Also to get in contact with other members and for networking purposes, very useful. So we have this pool here, and it was carried out to better understand which are the services provided. And we have these questions, for example, who are the NFTs creators in your game or platform? We asked this to the members. As you can see, there are some different percentage. For example, in-house, more 50% is the NFTs are made in-house. This is, by the way, this is not for all the members of the BGA. It's a part of them, of course. So 50% in-house, 33 all the above, which means also user and commissioned. So as you can see, the company here, there are some companies that give the possibility to users to create their own NFT, but at the same time, the company itself creates NFT. And some of them are offering these mixed services. Super interesting. Does your game or platform allow users to import NFTs from other games or platform? This is a revolution, in my opinion. I mean, think that you can import a sword that you won in a video game or that you bought from a video game, and you can use this sword in another video game. I mean, think about that. Unbelievable. But this is possible now. And so do they give this possibility? Yes, 33, no, 66. I think at the moment, this is just, this percentage is going to increase, because I mean, this possibility is very, 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 very interesting. Then, does your game or platform have a marketplace for trading NFTs? Yes, both primary and secondary, 83. I mean, when you have a marketplace, you must have terms and conditions. I mean, you want to stay as far as you can from transactions that happen there. You want to provide a service, but you don't want to be involved except from, taking the fees in the transaction. Another question, does your game or platform give the ability to trade NFT assets from other games or platform? A little bit different from the question that we saw earlier. Yes, 16, no, 50, it's our plan, 33. Also here we see it's mixed. So the bases are mixed. Last one, I think, does your game have any NFT royalties management system? This also is a revolution, guys. I mean, now with the use of the blockchain and the NFT, I'm the creator of an intellectual work, artwork, whatever. I can track what happens to the token that represents my creation. Potentially, I can take royalties from each sale of the token. Nice, huh? Here is 0% no, 50% No, sorry, 50% no, and 50% is in the pipeline. Just because at the moment, I think this is something that we need to work on, also technically and from the legal perspective. It is not something very easy. But I mean, just that a lot of companies are thinking about that, say something. Okay, just briefly, very briefly, then we move to, let's see if I've, oh yeah, okay, we don't have very much time. Okay, here there are some clauses, typical clauses that you may find in Eula, and here are some clauses that you may find in terms of conditions. You can see that it's packed much more than this, because they are more complicated than the Eula, as we said at the beginning. Here we go, food for thoughts and takeaways. In general, identify the business model, what you are providing, what you are offering to the users. If you're providing also a marketplace or just the possibility to create NFTs and to sell them, I don't know, directly, for example, to another user, not through the marketplace. Define what the users are getting from the company and what from other users. Super important also, to define which are the rights and obligations of the user, which rights they get when they buy something from you and from the users. Choose the applicable law. Very important. I don't want to talk too much about this, but it's very important to be subject to choose which laws apply to the services that you are providing. Manage the IP rights allocation, as we said. Be careful when you are a custodian wallet provider, because some regulations can apply to you, might apply to you. Distinguish between user-generated content and NFTs created by users. It's a tight difference, but there is. A user-generated content is something that, for example, it's a feedback that I provide on the website of the company, while the NFT is something different from just a feedback. Company does not warrant for NFTs qualities. Everything is based on blockchain, and is decentralized, so the company should not be held liable, except for in some particular circumstances. Which are the consequences for faking NFTs? If the user fake NFT in the way that it copies the asset under the NFT and does something that he should not do, he or she should not do. Considering with reference to the marketplace, keep it independent. You don't want to be a content provider, just a service provider, because in this case you can be found liable for monitoring transactions, and you don't want to do that. You want to have the faculty to monitor, but you don't want to have the obligation. Sometimes I see, the company has the right to monitor what happens. No, not at all. The company has the faculty to monitor and no obligation at all to take actions. Okay. Keep distance from users' transactions, as we said. State clearly how the company makes money in exchange for what. You don't want to get involved in claims concerning payments to your company. You want to get money and to be sure that you get money without getting involved in claims. Clarify what the users get when they purchase NFTs, as we said. We are referring here to the marketplace terms. Which are the obligations between users and between users and the company? Custodial wallets in case of the marketplace. There are some companies that are offering custodian wallets into the marketplace, not only in the platform, but also in the marketplace. If you're providing B2B versus B2C services, some people now are creating NFTs as their primary job, and they sell it for profit. So in this case, probably it's a B2B transaction, it's not a B2C. This has some relevance from the legal point of view, of course. I don't want to talk this now, but here some rules applies, particularly here. Here are some others. Maybe we'll talk about this in another episode. State clearly if you can refund or not, which is the policy for refunds. or return. In this case, a return or probably not, because we're talking about intangible assets, but I mean, who knows? And which are the rights of third parties? That's all. That's a quote. You will have time to read it because everything is recorded. And if you have any questions, here I am. Let me drop. Here we go.
Thank you so much, Luigi. It's been great listening to you. I was actually in the background taking notes because I think the amount of knowledge you shared, it's an incredible study that you went through. So thank you so much for making this available to our members and to our audience. I currently don't see any question, but I've seen there's been a great attendance today. So I think people are probably thinking all of these true.
When there's no questions, there are two options basically. The first one, I was so much clear that nobody has questions. So wow. The other one is that I wasn't clear at all, so people don't know from where to start.
I think it's definitely the first one.
I have a question actually.
Here we go.
I mean, everything was super clear, but the question came to my mind recently. And what happens if, for instance, you're selling or there's a marketplace for NFTs to crowdfund, and probably people who buy or purchase this NFT to fund, for example, an initiative, organization, or whatever, they wish to use this as a tax return or tax for tax stuff. I don't remember the word for that.
Deductions, probably.
Yeah, that one. So what would come next, and what are the options for these people who crowdfund this through this platform?
Tough question, Luis.
Tough question.
Tough question.
Yeah.
I mean, yeah, please.
No, sorry. Yeah, I know it's a tough question, and mainly because it's a very new subject, probably. But yeah, it's kind of I don't know. Maybe you don't have the answer yet, but
it's a very, very interesting question. A very good question. I was kidding. Of course, it's tough only because it touches different fields. So we are talking about NFTs first of all. So all the IP stuff, IP rights related stuff apply. We have to define which are the rights involved. We're talking about crowdfunding. So we have to be sure, we have to make sure that we are not talking about investment in securities. Very important. We don't want to get involved in securities laws. So what we are giving in exchange for the money that we are receiving, it's very important to state that. And talking about taxes, well, I'm not an accountant, but I have some knowledge of that because, of course, when we assist clients that involved in NFTs and blockchain and in general, we have to have some knowledge about taxes, and it really depends on the state and on the country. Generally, what we said today, it depends on the country in which you are and which laws apply. Okay, but especially when we talk about taxes, it really, like, I don't want to say 100%, but it depends a lot on the country where you are. So if you're in the US, some tax laws can apply. If you are under the EU legal system, some other applies. Actually, from the tax perspective, each member state of the European Union has its own tax system. So I'm afraid I cannot give you an answer like that. But it's something that I would like to go to examine much deeper because it's a very interesting topic. I don't know in which country you are planning to do, or that this is happening.
Yeah, well, it all depends because since it's thought to be a global platform, probably will welcome people from all over the world for either crowdfunding or people who want to fund. So I know it might get a little bit tricky sometimes when thinking about that, but I absolutely agree that it depends on the country and where the people is located at, et cetera, et cetera.
Let me give you an example. Me, as an Italian citizen, if I invest in a company, in an Italian company, I can deduct from the taxes a certain amount, 50% actually now, of the amount that I put in the company. Okay, but only if I'm investing in an Italian company. So if I'm here in Italy and I'm investing in this project that is in the US, for example, the company is based in the US, or the association that is providing this, that is offering this crowdfunding, I'm not sure actually that I can deduct that from my taxes. So it really depends a lot.
Okay, agreed. Thank you.
You're welcome.
Yeah, I think this is also a great opportunity for any of the people that have been watching this and whoever is going to watch this at a later stage to get in touch with Luigi. If you're in need of further assistance on EULAs and terms and conditions for your games, your projects, I think really Luigi has a great expertise around this area, and we definitely feel at the BGA that this has been incredibly useful, and we hope that you guys and everyone else can benefit from this knowledge being shared.
Thank you very much, Serena. Feel free to contact me. It's my contact details are in the last slide, and I'm really happy to provide you with any suggestions. So feel free to contact me at any time. Super happy to do that.
Thank you so much. It's been a pleasure having you. So thank you everyone who's been here watching and following the workshop. Thank you to the BGA members that participated into the survey and took part into the internal workshop we had earlier this week. And thanks again to you, Luigi, for bringing this content together.
My pleasure. See you next time.
Thank you.
See you. Take care.
See you next week.